So, Mr. Kirpal, thank you so much for speaking to me on Times Now's Turning the Page. Your book, 15 Judgements, Cases That Shaped India's Financial Landscape, is out. And this is a thorough examination, pretty much, of India's financial history post independence through a scrutiny of at least 15 inflection points where the courts have had to intervene. I'll begin this interview with an overarching question, Mr. Kirpal. As someone who's actually closely monitored judicial proceedings in matters of the economy, is the Indian example that of a more interventionist court, especially the Supreme Court, in matters of the economy than most other democracies?
I think the answer to that is a resounding yes. We have a more interventionist court in virtually every sphere that we see. So it's not surprising that when it comes to the matter of the economy, the court again becomes interventionist. And there are many instances of it in matter of ecology, corruption, but also larger public policy. The courts are more willing to step in than they would be elsewhere. There is a sense in other countries that parliamentary supremacy forbids judges from intervening. But our courts say that the Constitution is supreme, and they see sometimes themselves as the supreme or sometimes even the sole guardians of the Constitution. So they often venture in and intervene in areas. Sometimes that is justified, but as the book discusses, sometimes that intervention is maybe excessive and not warranted.
In fact, I must congratulate you on the book, and also the fact that you're very forthright in the opinions that you basically cast on several judgments. Some of the landmark decisions that have been taken on the part of the Supreme Court, and you don't shy away from taking a categorical position on these judgments. So let's in fact begin with the fundamental right to property and the very fact that the First Amendment to the Constitution was brought in even before we had an elected parliament. This was, of course, an interim parliament following independence. So thanks to the First Amendment and the promulgation of Articles 31A and B, which allowed Parliament to pass laws under the ninth schedule and therefore evade judicial scrutiny, that's where the fundamental right to property was actually brought to its own death, so to speak. You also cite the examples of the Foreign Exchange Regulation Act, as well as the Essential Commodities Act, amongst others, that have been passed under the ninth schedule. But do you believe that the perceived tyranny of the majority that the ninth schedule appeared to have given a free pass to has somewhat, in hindsight, subsequently been tempered by the IG Coelho judgment in 2007, where the court said that the provisions cannot confer, quote unquote, an unlimited or unregulated immunity to Parliament? Or do you believe that threat of a tyrannical majority using the ninth schedule to push through legislation that might basically trample upon fundamental rights, do you believe that threat still remains?
Again, I don't know how well-informed your audience may be on rather technical matters of the law. And we're banding about words like Coelho and ninth schedule. So maybe I can just give a brief explanation to your viewers as to what it is. Now, when the first amendment to the Constitution was made, it was in response to the Bihar High Court striking down legislation which abolished zamindari. And that was on the ground of the right to property that existed in the Constitution at that point of time. So obviously the government was incensed with this decision and wanted to undo it. And they came up with a unique method as to how to amend the Constitution. They inserted what is called the ninth schedule into the Constitution by virtue of Article 31B, and said that whichever act Parliament puts into that ninth schedule will be then immune from judicial scrutiny, and that act cannot be struck down if it is violative of Article 14 and 19 and 21 and certain other fundamental rights. So it became like a kind of a black hole, which gave omnibus protection to all kinds of acts. Whereas the idea was only on land reform and zamindari abolition. That's why the First Amendment came. The ninth schedule was open-ended. And we know that when any power is given to the Parliament or the executive, which is open-ended, it is going to be used maybe more than what is originally envisaged. And that is exactly what happened in our constitution and our history. That even though zamindari was the original idea, cases, as you said, FERA, Essential Commodities Act, many other pieces of legislation were put in the ninth schedule. And then the courts were said, well, they may be completely unconstitutional. They may be arbitrary, they may be irrational, they may take away your right to do business, all of which are fundamental rights. But sorry, because we have now put them in the ninth schedule, you have to keep your hands off it. And the ninth schedule had been upheld by Parliament, by the courts even in Shankari Prasad, and then ultimately in Golaknath, even though it was struck down, it was only struck down prospectively. So the insertion of Article 31B into the Constitution was upheld even in Golaknath's case in 1967. But the worry was that you keep on inserting, and I have the Constitution in front of me, I can check how many acts are in the ninth schedule. Hundreds of all kinds of acts, both state as well as central acts come in.
Including reservations.
So then, including reservations are part of Article 16, 15, and they may be independently part of the Constitution. They may not come in the ninth schedule. But certain other acts do find their way in the ninth schedule. So then comes, of course, a kind of a backlash. So you have a judicial decision, you have a backlash of Parliament. Parliament then starts abusing its powers. There is then a judicial backlash. So it's like this is the story of our constitutional development. Then comes a judgment in Minerva Mills in 1980s, which is then taken forward ultimately in this 2007 judgment called I.R. Coelho. Now, Coelho decides two things. That yes, you have this ninth schedule, the constitutionality of which has been upheld. And there's doubt about that as to whether it's been upheld or not. But two things will follow. Is that when you put something in the ninth schedule, that insertion in the ninth schedule will be tested on each occasion. So you can't say that just because ninth schedule has been upheld, I can choose whatever I want to put into that black hole. Okay. Now, every time you insert an act into that ninth schedule, you will check whether that insertion amounts to violation of the basic structure of the Constitution. That's one. And secondly, and there is some ambiguity in the Coelho judgment, and I think it was an opportunity and an occasion for the court to have clarified the law, but I think the court left it a bit in a gray area. So there is a famous golden triangle argument that the three fundamental rights of our Constitution, Articles 14, which is right to equality, Article 19, which is the right to freedom of trade, business, free speech, etc., and Article 21, which is the right to life and liberty, are so fundamental to the Constitution that they themselves form the very basic structure of the Constitution. So if any act is put into the ninth schedule, even if it is put into the ninth schedule, it can be tested on this golden triangle of 14, 19, 21. And had that been said, then of course a large part of the force and vigor of the ninth schedule would have been taken away. But the judgment is not so clear. It has all kinds of loose concepts, including the central right, the core right, the penumbra right. So I think sometimes judges, when they give judgments in a desire to add caveats and use flowery language, they take away from the centrality of the decision. And Coelho, I think, was a moment lost. So yes, the ninth schedule has been weakened after Coelho, but it is still very much as a beast alive and kicking, slightly wounded.
Let's come to another aspect of the book. And you cite a very interesting quote, Mr. Kirpal, by Mr. Kumaramangalam, when he opposed the Supreme Court's decision to strike down the attempt by the government to nationalize banks in 1969 by way of a legislation. And he said, and I quote, "To permit the present decision of the Supreme Court to remain as the law of the land would mean giving the courts a power that would block any possibility of building a socialist economy within the framework of the present constitution." Stop quote. Now, this is with specific reference to the government's move to nationalize banks in that particular year in 1969. But even today, the central government in the demonetization case, which is currently being heard in the Supreme Court, did not want to, have the court turn the clock back. This is their court, or unscramble a scrambled egg. This is again what they've said. Now, how do you think the dynamics of this turf war between the center as well as the judiciary over matters of examining economic policy has changed over the last 50 years, or are there still aspects that still remain the same?
I think in matters of economic policy, they can either have a constitutional impact, or they can be matters of pure policies, which are then judged on the general grounds of rationality, etc. Now, I see, at least in the research that I have done, courts have become far more deferential to the decisions of the government in the last 50 years. So you take the two examples yourself of course, the demonetization case, we do not know. Judgment is reserved and it will be pronounced in early January because one of the judges is retiring on that bench. So it will come. But at least if we talk of the earlier case of bank nationalization, uh, Kumar Mangalam, Rangaraj Kumar was extremely one of Mrs. Gandhi's acolytes, and she had a group of people around her who
Yeah, he
are
called them the Young Turks.
the Young Turks. Chandrasekhar was one, and so the book discusses the politics of its time as well. And there was, I think, a feeling, at least in Justice Sikri's court, because I would call until Kesavanand Bharti, he retired the day it was pronounced. So this was, of course, another one of Justice Sikri's judgments, R.C. Cooper, which is the bank nationalization. So the Sikri court was actually quite interventionist. And I think that's something we don't talk about enough. The way in the US we talk of the Berger court, the Rehnquist court, the Roberts court now, and they are either interventionist or not, right wing or left. Even in our court, I find that it is the era of the Chief Justice which defines how interventionist the court is. So in the earlier parts of, I think, the Constitution history, courts were far more interventionist, especially in matters relating to fundamental rights. They saw their roles as wanting to step in and correct any error if it violated the fundamental right of a citizen, no matter what the economic policy. So even a matter as big as nationalization of banks, which affected and which was needed at that point of time potentially, because a vast amount of India was underbanked and money was lent only to certain sectors and not to other sectors where money was needed. For instance, agriculture never got any money. But the court stood up and said, sorry, as long as there is a fundamental right which is violated, even of one person, then we will step in. Now we see that today, I think courts will be more reluctant to do that. I think they see their role as almost balancing fundamental rights versus the interests of the public. Now, I'm afraid that is also an error on the part of the courts, because it is no part of the court to do this kind of balancing. Balancing is already envisaged in the fundamental right protection itself, right? So Article 19 gives you a right, and Articles 19.2 to 19.6 give an exception on the balancing. So the balancing is within the right. You don't balance a right with a government interest necessarily. You balance a right within the limitations provided for in that right itself. So in 19.1a, you will balance that right against public order. In 19.1g, which is freedom of trade and industry, you will balance that against interests of general public. But you will not take into account, you're not supposed to take into account any factor extraneous to the right. So when you start balancing and you take extraneous factors like economic policy and that is a problematic thing. Now, again, I should go a bit further from here. That does not mean that even when the court does do the balancing exercise or should do or should not do, that the court should go ahead and strike down legislation. Even if it is slightly reticent and it comes, I think the economic impact of every decision must be examined by the court in the ultimate order that it passes. And we've seen also, of course, in cases in the recent past, that while, yes, I say the court does give more of a pass to the government in matters of policy, in certain matters it has not given that pass. And I think it has probably been a bit wrong there, but we can discuss that.
Yeah, we will. I mean, one of the references, of course, that comes to mind is the 2G judgment where it cancelled 122 licenses. So we'll come to that in just a bit. But in one of your earlier answers, Mr. Kirpal, you did talk about the flowery language sometimes used by the court, and you cite a very important instance. In fact, a judgment that was delivered by Justice Krishna Iyer in the matter pertaining to the challenge to the Industrial Disputes Act. And let me, in fact, quote Justice Iyer here, where he says, esoterica is anathema for law affecting the common man and the commerce of life. And so the starting point of our discussion is the determination to go by the plain, not the possible sense of the words used in the definition, informed by the context and purpose of the statute, illuminated by its scheme and setting, and conceptually colored by what is an industry at the current developmental stage in our country. Stop quote. Now, we'll come to the merits of this particular case in just a bit, because that's my next question. But coming to this specific aspect about flowery language, it's not something that has stopped with Justice Iyer a lot of the subsequent judges have also ended up indulging on this kind of lingua when it comes to authoring their judgments. So the fundamental question here is, if the judiciary is to bridge the divide between itself and the citizens, are such judgments serving any such purpose?
Absolutely not. They do a great disservice. Now, you see this quote itself. Now, I think it's very difficult for anyone to make head or tail of it. But fundamentally, what the learned judge, and he was a brilliant judge, I wish he just used easier language. He says esoterica is an anathema to the law, right? Which means esoteric language, complicated concepts, don't use them because that's anathema to the law. And yet he's saying that himself in his own judgment. This is a complete paradox, and that's what I comment on in the book. So, as it is, we live in a country where there is such little legal literacy. People are not aware of their rights. People do not know how the judgments are delivered. People do not know how the judges work. We now have a YouTube channel, at least, and that's good that people can see what's happening in YouTube. But it should be possible for an average citizen of our country to be able to pick up a judgment and have some hope of understanding what is it that they've decided. Because after all, these are judgments that impact the lives of citizens. If it is written in a language which is so difficult to comprehend for a lawyer, let alone a layperson, judges are just pushing themselves further up that ivory tower that they already are in. But the effect of them going up the ivory tower is that the common citizen does not understand what her or his rights are. And that, I think, is a very dangerous thing. And it's counterproductive, because the less there is comprehension of what is happening in the courts by the citizen, the greater the power of the politicians to step in and misinterpret what is happening. Because otherwise, judgments can speak directly to the citizen. And you can read and see what the judgment has said. But if you don't have that capacity, then people will come on in the middle and say, well, this is actually what it means, and misinterpret a judgment. So that is a bad thing. Maybe people like me, of course, who also have come in and said, this is what a judgment means. And that's the book I've written. I've tried to be fair, but not everyone will be.
Now, in fact, coming to the meat of the challenge to the Industrial Disputes Act, and in the Bangalore water supply case, I think that's the case that we're talking about here. And just to talk about your view on what appears to be a case of both executive as well as judicial lethargy in this matter, if I may use those words. The Parliament in 1982, following this judgment, had passed a law, like you write, redefining industry, but this law was never notified. Then the Supreme Court decided to refer the law to a constitution bench in the year 1998, a bench that was formed 7 years later in 2005, and said that the earlier judgment in the case of the Bangalore supply matter was in fact wrong. Now, the matter, however, continued to remain in abeyance, and it was in 2017 that a final larger bench was once again formed. So, and it's still pending. So 5 years since 2017, there's been no resolution to this particular matter. And you also write that there are several states as well as the center that has actually tried to bring in labor reforms by virtue of legislation, but those legislations too have not been notified. So there's actually no proper resolution to this entire matter. So my question therefore is, what explains both the judicial as well as the executive lethargy in this matter?
Well, what explains it is the nature of issue at hand. It's a politically explosive issue. The issue really is about the rights of workers. And we as a poor country have a large amount of vote bank which are comprised of workers. So the politicians will be loath to touch an issue which takes away workers' rights, because they will be seen as anti-worker, and that is not a politically sensible course of action for them, for some of them to take. Now, of course, you mentioned labor codes have come into play, and maybe they will change. But the fact is they've not been notified yet, and they've not been operationalized yet. So that is why the Parliament is lethargic about matters pertaining to rights of workers. What is difficult for me to understand is why the courts are similarly lethargic, because obviously they're not answerable to the population. To there the answer is quite simple, I suppose. If you go back to it, this is a phenomena that plagues the courts generally. That the courts are just simply too slow, and that, I think, holds back our economic development. Decisions are not taken fast enough. Matters that do not merit the time of the court end up taking a rather large amount of time of the court, and in the consequence, because the time is limited, matters which need to be urgently heard by the court are not in fact heard by the court. So an issue of Bangalore water supply, which is what is an industry, has been languishing in for pronouncement for authoritative legal verdict for 40 years. Now that is just absurd. Once you decide that your earlier view in a particular case is wrong, and the reference of the 5 judges said that this earlier judgment of Bangalore water supply is hurting industry. Now, if you recognize that earlier judgment of yours is hurting industry, you believe that course correction is needed, you then need to step in and do that actually. But because I think maybe the courts are so overwhelmed by the sheer number of cases before them, and they're trying to sit in benches of 2, they have no time to hear matters where you need to sit in benches of 7, 9, or larger. So this has to be heard ultimately by a bench of 9 judges, because Bangalore supply was a 7-judge bench, so it'll have to go to a 9-judge bench. And that 9-judge bench has simply not been constituted. I think the last one was maybe Coelho's case. It's not happened since. So it's about time. And there are matters in the Supreme Court pending 9-judge benches, 11-judge benches, including matters relating to the Bombay Rent Act. But when will they be constituted? We now have 34 judges of the Supreme Court of India, and we don't have enough time to have a 9-judge bench. Yet, when there were only 7 or 9 judges in 1950 in the Supreme Court of India, virtually every judgment was a 5-judge bench. So in 1950, with 9 judges, they can sit in a combination of 5. Why in 2022, with 34 judges, can you not sit in a constitution bench of 5, 7, or 9? It's probably the pressure on the court.
Okay. In fact, coming now to a central question that your book raises, and that's something that I want to ask you. What is your own view over where the court actually ought to draw a line? Now, let me cite a few examples. Now, for instance, when you write about the Tata Cellular case, you're quite critical of the court when it left the executive with far too much power over the framing as well as the execution of the tender process in public procurement. And let me quote what you write. You say that the net result of this judicial reticence is that rather than being a means for bringing transparency into the system, the tendering process has become a virtual black box. And yet, when there is a pronounced intervention by the judiciary, when it came to the cancellation of the 122 licenses, something that we referred to earlier as well in our conversation, pertaining to the 2G spectrum, there is again criticism that the court has gone too far, a view that you also share. Now, how far is too far, Mr. Kirpal, and how little is too little when it comes to these matters and the court's intervention?
Yeah. Now, the two cases can be very easily reconciled if we remember that there are two concepts at work. One is an issue of what is constitutional, and second is the issue of what we do with something once we find that the constitution has been breached. Right. So there is a substantive error that is to be found in the one case, and what you give as a relief, as a consequence, is the net result. So we keep this distinction in mind. It's very, very important. What Tata Cellular says is that the moment any terms of a tender are framed by an authority, we will not even look into them. We will see only the very limited circumstances that tailor-made for one particular individual, i.e. there is some kind of favoritism or a bias. Now, we all know that favoritism and bias is virtually impossible to show. So the courts will say that we will not even look into it, and therefore the constitutionality of it will not be examined. I think that's wrong. The courts have a constitutional obligation to examine everything and see on the touchstone of arbitrariness or Article 14 as to whether passes constitutional muster or not. So there, I think Tata Cellular is wrong by giving a free pass to the executive that, look, we won't touch what you do. You can do what you want to. We will not examine it. This kind of blinders that they put on, that is the problem. Now, having put on the blinders, and if you take off the blinders, it doesn't mean that you can do everything. If you find some error, that you go and use a sledgehammer to kill a fly. So now take the example of the 2G case. They examine the constitutionality of it. They find that the 2G licenses were wrongly given. Fine. And I think that's correct. That is the job of the court. They should have examined this. My problem is not the fact that they found that it was unconstitutional. My problem was that thereafter they proceeded to cancel 122 licenses. Now, to take the example earlier, what in Tata Cellular, what is the correct thing to have done? There's a case, for instance, I don't discuss it in my book, called Suhash Constructions, which said that the courts had found that there is some kind of an error in the award of a tender. And that was a clear finding. Even with a limited scope of judicial review, the court found that there is an error What the courts did then was that we will not cancel the tender, cancel the contract because that is not in the public interest. We will impose damages. And they proceeded to impose damages of, at that point, was 1 crore, which is a very hefty sum, but they can enhance it or decrease it. So that is a correct approach. In the 2G licenses case, once you find something is unconstitutional, you must understand that the original people who wrongly got the telecom license are not even there in the picture anymore. Those licenses have been sold to innocent third parties, including foreigners. When they purchased those licenses, they were not aware that anything is illegal or unconstitutional. So when the court finds that there is unconstitutionality, the right thing to do was not to cancel the licenses, but to have imposed some penalty, initiated some prosecution, asked for some for the regulator to step in and increase tariff. So many other kinds of alternatives are possible rather than cancellation. So I think when I say the court went too far, I say it went too far not in finding unconstitutionality, but in the nature of the relief it gave.
The other case that you also discuss is, of course, the Vishaka guidelines, the Bhavari Devi case as well, pertaining to sexual harassment of women in workplaces. How would you respond, Mr. Kirpal, to those who say that the Prevention of Sexual Harassment Act, or the law that was eventually passed. Now, there's a lot of criticism about the law itself, something that you speak about in the book too. How would you respond to those who say that the POSH law should in fact be gender neutral? That's point number one. And Section 14 is something that you criticize because it provides for penalty against false complaints which have been brought to the table by the complainants in the matter in the event that they're proven to be false or malicious. Don't you think that is actually an adequate safeguard in the law to protect people who might perhaps be at the receiving end of false and malicious complaints? How do you respond to those two questions that are being raised about the POSH?
Right. On your first point as to whether POSH should be gender neutral, I think it certainly should be. There is no question. There is no reason. You have of course, a particular problem which is largely applicable to women in our country. Sexual harassment is largely a phenomena that is faced by women in our society. And therefore, it is only correct that when the court gave its verdict, POSH came, that the focus was on women. And the sexual harassment is typically by a man against a woman. But times are changing now, and we do see increasing instances of harassment of men, both by their female or their male bosses even potentially. So I think any kind of harassment at work, any kind of toxic work culture needs to be curtailed, and therefore we need a gender-neutral POSH. That's need of the hour. As regards my criticism of Section 14, look, it is not as though we have had and we've had Vishaka from 97. We've had the POSH Act for the last 7 years now, 9 years now. And it's not as though we've seen a whole floodgate of complaints that have started coming. Complaints are still few and far between. People want jobs. They don't want to make complaints against their bosses. So it's on a very rare occasion that a sexual harassment complaint comes. Complaints are, in any case, are not going to be made by people who are terribly disempowered already. So what the problem of Section 14 does not recognize this realistic power dynamic, that you already have a disempowered person and you're disempowering them further by having a Section 14 kind of a restriction that in case you make a false complaint, we will punish you. That person is already petrified that I'm not going to be able to show my complaint and I will lose my job consequently, because you can be fired in any case from your job. You're concerned about how I have to continue working in this particular organization because it's not that there's so many jobs. What do you do? So to take that courage to make a complaint under Section 40 of sexual harassment, it's not an easy task. And when you then discourage it further by having this kind of a clause of Section 14, I think this is misguided. There is, of course, a requirement to ensure that there is no abuse of any law. But every law is prone to abuse, right? Mm. So what is unique to sexual harassment? Why not this, after all, the government comes and foists all kinds of cases of tax evasion, this, that on people. Why not have a general law there, say that this is false and therefore you have malicious prosecution as a criminal offense. But those all kinds of restrictions there, that is not easy thing to use. Why don't you do it there? That's fine. But when a woman wants to complain that she's being harassed, that is suddenly you think no, that a man will be troubled and abused. This is the general mindset of patriarchal thinking that we have. That needs to be therefore controlled.
Okay. On the issue of Aadhaar, now you believe that the jury is out on the efficacy of Aadhaar, but do you believe that the court has been sensitive to fundamental rights, including privacy, in the context of the Aadhaar judgment, because it did uphold the fundamental right to privacy in the Puttaswamy case. Now, I ask you this specifically in the context of a worrying submission that was made by the government of India that the Constitution of India did not recognize the right to privacy. So, in that light, how significant is this judgment, and what kind of a precedent does this judgment set for future judgments pertaining to the right to privacy?
Right. So we must remember Aadhaar had part one and part two. It was really not one composite judgment. And it was rather, if I may say, obnoxious statement on the part of government to say that our constitution recognizes no right to privacy. This was in spite, of course, of an early judgment of MP Singh, which had said that loosely, but from 75, from Govind's case onwards, it was well understood that the constitution had a right to privacy. And so the matter is referred to a larger bench. And that bench then gives an authoritative pronouncement, says that the government is absolutely wrong, unanimous verdict, that our constitution recognizes a right to privacy. Its contours are to be found in Article 21 largely, but also in certain other parts of the constitution. And privacy means different things. There's a privacy, which is data privacy. Privacy means privacy in autonomy and dignity. So in different times, the right to privacy means different things. So that's probably, I think, the most important part of the Aadhaar judgment. The Aadhaar will come and go as a scheme, and the Puttaswamy 2 will come and go. This judgment, which gives us the right to privacy, now this will, I think, stand the scrutiny of time in a very similar manner to the Cooper's case, bank nationalization. The bank nationalization was struck down. They were ultimately nationalized in any case. But Cooper's case today is remembered not for nationalization of banks, but about how it said that fundamental rights are to be read as a composite whole and not in individual silos. So this constitutional jurisprudence laid down in R.C. Cooper's case and the right to privacy, the constitutional jurisprudence in the other case, now this will endure in the future. But coming back now to Aadhaar 2, in terms of drawing of the balance between right to privacy and the interests of the majority or the government in distributing state largesse, a balancing act has been done. And that's why the jury's out as to whether it's efficacious or not. Because the argument is, I'm selling a bit of my privacy to buy a bit more of efficiency. Now, is that a permissible trade-off that the Constitution recognizes, that you sell your fundamental right to get a benefit? I don't think it is, but I think Aadhaar was needed at that point of time. And I'm not one of those people who is innately anti-Aadhaar. I think it's a system that works, that if there are problems, they need to be fixed. But to the extent that the court did, I think the court did an act of judicial statesmanship. I think the court was probably correct there in the decision it took by weighing and saying that in matters relating to subsidies and public funds, you can use Aadhaar. But the excesses that were happening with the Aadhaar scheme, that Aadhaar was being given even to private entities for, say, phone verifications. Or I remember at one point of time when I used to go to the post office or the courier office, you have to give your Aadhaar card, which was then linked and checked. Now that was an unacceptable invasion of privacy. So that was struck down by the courts. So I think the courts are right in trying to draw a balance. But of course, courts are not going to judge economic policy. That has to be done by the electorate. That has to be done by history. And that we shall see as to whether the Aadhaar scheme succeeds. I don't believe in the great ability of the government to, I don't doubt their intention. But I think sometimes we forget that intention is no substitute for actual delivery and hard work. So on whether Aadhaar will work, we shall see. Intention, I'm not doubting, but I seriously doubt the capacity to deliver.
A final question now, Mr. Kirpal, and something that, it's a very recent case, the Ambani's case that you talk about the distribution of resources pertaining to gas. And I want to end the interview on an interesting observation that you made about the judgment, where you said it parts of it actually read like the Communist Manifesto. And you also believe that there's a fundamental issue here, especially when Article 297 was invoked by the Supreme Court, and that perhaps was the deciding factor in how the judgment actually progressed, where basically anything of value under the ocean, minerals, etc., or above a piece of land is vested with the central government. And then you had a problem, of course, with the fact that the central government could actually market that particular product and also decide on the price. What kind of a precedent does this set? And what does it tell you about the evolution with respect to the rationale of the court pertaining to economic policy between the 50s to now? Has it remained constant in one particular element, especially with kind of findings that we had about the court in this case?
Well, no, the court has, I think, moved very decisively, at least in that to the left. And this was one particular judgment of Justice Reddy, I think, who had a very, like Justice Krishna here, a very left-wing approach to things. And I think we must always remember, the way I talked earlier in the interview about how the Chief Justice's role is very important in determining how a court decides. The particular view of a judge is also very important as to how a decision is in a particular way. So I think from the freedom that was given and the meaning of Article 19(1)(g) that was given in 1950s, and the courts repeatedly intervening to protect the right of free trade and business, to now, when I think effectively what happened was a nationalization of the gas business. And the court upheld that nationalization and in fact almost mandated it. There's bits of that judgment would say that should happen. I mean, these public resources can be used only for government. This shows is that the court has moved from the laissez-faire ideas it had in the 1950s, when it used to regularly come and protect the rights of business. It had struck down monopolies up till 1906 was amended. But we have Justice Reddy, who is already a person with relatively left-wing ideas. And as I said earlier in the answer about Chief Justice is determining how the court functions as a whole, certain individual views of judges also come out in their verdicts, as is to be expected. Of course, this was surprising because we have liberalization of the 1990s, and you think by this point of time, the judges would be slightly aware of how you deal with natural resources, how markets work, and the belief that the government is the ultimate owner and has the best interests of everybody at the heart and is most capable in determining distribution of natural resources is not probably a correct view, given the past history of what our country was politically and economically. But that is a view that is reflected in the judgment. So that's absolutely, I think, it was not necessarily a correct view there, because that has a very negative impact on how businesses are ultimately work in India. But what do I think of the judgment in terms of nationalization as well? Effectively, what the judgment says is that all the gas belongs to the government. The government can decide where it goes, which price it is sold at. And if that is to happen, then why will any entrepreneur ever decide to have the risk of drilling for gas and seeing whether gas is there or not? Because all the risk is that of the driller, of the explorer. But if you strike gas, it's a very expensive process. And but suppose you find that there is lots of gas, but you can't decide whom to sell it, at what price to sell it. In a time when market forces are now accepted as, okay, they may not be the magic hand of the market. I mean, we don't have that kind of laissez-faire idea as well. But this belief that there should be no marketing freedom whatsoever, this is also an antiquated idea. So that what I advocate in my book is that you have to have a regulator in place. You need regulated markets. You can't jump from nationalization on the one hand to complete laissez-faire on the other. You need regulated markets because there's a possibility of abuse from both sides. Of course, we need an independent regulator. We have a Director General of Hydrocarbons, but his role is not to decide either marketing or pricing of the hydrocarbon. It's on a different thing. So maybe we need a regulator where prices are allowed to be determined by the market. They are, after all, determined in petroleum, right? We don't set prices of petroleum. That's set internationally by crude. So just because you have a captive person producing gas in India, you can't start squeezing them and saying, no, Now we are going to force you to sell gas at this particular price to this particular person. That will not work in the long term in the interests of the country. And this is again an instance I thought of the courts not being completely in sync with market reality. And while, of course, the court's ultimate oath is to the Constitution of India, it can't be that while taking the oath, they say that in the famous, that Lady Justice with a blindfold, that you are ignorant about the impact that your judgment is going to have on the economics of of your decision. They should be aware of that.
And do you see these battles being played out in the Supreme Court for a long time to come? Because there's, of course, allegations of encroachment by the judiciary in the executive and the legislative domain. But there's also, of course, the question of executive as well as legislative lethargy, which have sometimes prompted the intervention of the courts in these matters as well. So this is a tough battle that will continue for the long run, something that's been an issue for us since the 1950s, ever since we became independent.
Look, I'm a firm believer that a tough battle is not a bad battle. Ultimately, we have a system of separation of powers. We have a system where the court, as the alleged guardian of the Constitution, is supposed to ensure that the parliament and the executive do not overstep the boundary and stay within the constitutional limits. So it's meant to be a check on executive power. Now, no one likes the power to be checked. Everyone wants as much free reign as they possibly can. It's a natural human way of behaving. So obviously, when the courts step in, they're going to be met immediately with cries of the fact that there is overreach and overstepping. So this friction is inevitable because of the design of our institutions. If we have a system of checks and balances, it's natural that there will be this friction. And friction is good. We don't need a kind of again, Russian communist idea that all institutions are marching together with one unified purpose. We saw that happen in the 70s with the idea of the committed judiciary. It didn't work then. Yes, it didn't work then. It didn't work then and it will not work now. We need, if we want to have a system that works, a belief that it is not as though one person alone who's always right. We need a collegiate decision-making process. And part of that collegiate decision-making process is the right of the courts to intervene and step in perceived excesses. But that is going to cause tough wars. And so be it. As long as those wars don't result in the murder of one institution, minor skirmishes will happen.
Okay, thanks a lot for that conversation. It's a very insightful book and many congratulations once again. 15 Judgements, Cases That Shaped India's Financial Landscape by Mr. Saurabh Kirpal. Thanks a lot for speaking to us. It was a fascinating conversation, sir.
And thank you for having me, Siddhartha.
Thank you.
I enjoyed having this conversation with you and your audience.
Thank you. Thank you so much.